Good evening. Welcome. My name is Kathleen Winters, and I'm the Executive Director for the Northern District Historical Society. The Historical Society and program co-sponsors the 9th Judicial Circuit Historical Society and the Northern District chapter of the Federal Bar Association extend a warm welcome to all of you joining us in person and virtually. A few reminders. For in-person attendees seeking CLE credit, please sign the CLE sign-in sheet if you have not done so already. For those attending remotely, a CLE code will be announced during the program, and it will also be posted in the Zoom chat. And please remember to silence your cell phones. Thank you. Our deep appreciation to the panel for taking time from their busy schedules to be here. Special thanks also to Rowena Espinoza, Judicial Assistant to Chief Judge Seaborg, Stephen Curl and the 450 Golden Gate building staff, Audrey Barrett of the NJCHS, Alexander Murray of the NDHS, and Valerie Stewart of the FBA. Please check your email for information about how to join the Historical Societies, support our efforts, and learn about future events. We cover a wide array of topics with connections to the Northern District and the 9th Circuit. Examples include recent programs on war crimes, California's history with respect to local indigenous populations, voting rights, immigration, and the implications of the Dobbs ruling. We have another lesser-known stories program for Black History Month set for March 10th, and we plan for a program this spring on the rise of the female trial lawyer in the Northern District. We will also be presenting the Bill Edlund Award for Excellence in the Law later this spring. These events are all made possible by memberships and donations. It's my pleasure to now hand things over to Randy Sue Pollock, President-elect of the Federal Bar Association Northern California chapter, who will introduce our distinguished panel. Thank you.
Thank you, Kathleen. In honor of Black History Month, it's a pleasure for the Federal Bar Association Northern District of California chapter to present this program to remember the Port Chicago 50. To begin with, I'd like to take a moment to welcome all Federal Bar Association members and to encourage those who are not yet members to please do so. Our chapter here in the Northern District is a very active chapter. The Federal Bar Association serves the interests of all federal practitioners, both public and private, the federal judiciary, and the public. I'd like to take a moment now to introduce to you our new president of our chapter, Nicholas Walsh. Nick, if you could please stand up. Our chapter had a program last month. It was sold out to full capacity in this courtroom of Judge Alsop speaking about common mistakes that attorneys make in cross-examination. We have an upcoming program March 24th in Stanford at the law school entitled Clients and the Courts that's going to deal with in-house counsel. Several of our judges from this district and local practitioners will be participating in that. It'll run from 1 to 5 p.m. on Friday, March 24th. We also plan to have our 9th Circuit Judicial Luncheon here in September 23rd here in San Francisco. This is an event that we used to hold annually, and we haven't had it in 3 years due to the pandemic. So you will be getting flyers about that, and I encourage you to come. It will be all the judges, many judges from the 9th Circuit, as well as our court. To begin, turning to our program today, remember the Port Chicago 50 is a two-part presentation of a significant chapter in the struggle for civil rights. In the first part of this program, we will present the history of the Port Chicago disaster, a massive and deadly explosion at the Port Chicago Naval Base in Contra, Costa County, and the mutiny trial of the Port Chicago 50 that followed. You will hear actual trial testimony of 3 members of the Port Chicago 50, selected audio clips from oral histories given by several of the men, and the stirring words of Thurgood Marshall, from his legal brief to the Secretary of the Navy. What will become evident to you is under the discriminatory reality of that time, 1944, any defiance by a black soldier of an order given by a white officer was considered mutiny, even if the order was an unjust one or an immoral one, or placed soldiers in grave danger. In the second part of our program, we will turn to a discussion of the ongoing efforts to exonerate the Port Chicago 50. Before we turn to our historical reenactment, I'd like to introduce the members of this presentation that you will be hearing from. Okay. Right behind me on the far left is Yolanda Burial Knight. Ms. Knight serves as the clerk of the board for the East Bay Regional Park District. She co-founded the Black Employee Collective, which was established in 2020 to promote diversity, equity, and inclusion and belonging in the East Bay parks. She played a prominent role in naming the newest park in the East Bay Regional Park District, the Thurgood Marshall Regional Park, which is the home of the Port Chicago 50, and she serves on the Contra Costa County Bar Association Port Chicago Task Force. Many of the members that I'm going to be introducing are members of that task force. Mark Conrad, who is seated in the middle behind me, is a trial attorney and founding partner of Conrad, Militsky, and Kane, which specializes in complex civil litigation here in San Francisco. He's a leader and active member of the legal community in San Francisco and currently serves on the Justice and Diversity Center of the Bar Association for San Francisco. Seated next to him is the Honorable Haywood Gilliam. Judge Gilliam has been a member of our court since December of 2014. He served for 1 year in 1994 to 1995 as a law clerk to Judge Thelton Henderson. He was an assistant United States attorney here in our district from 1999 to 2006 and served as chief of the securities fraud section from 2014 to 2016. Presently, he is a co-chair of the conviction alternative program in our Oakland division, which is commonly known as CAP. Seated here at the prosecution table is Tom House. Is it Commander? Okay, Commander House retired. You see him in his uniform. He retired from the Navy in 2021 after more than 24 years of service and reaching the rank of lieutenant commander. During his naval career, he served in a variety of posts across the world, including 2 years just before retirement as executive officer at the Military Ocean Terminal, also known as Port Chicago, what remains an active military facility. He is a passionate proponent of exoneration for the Port Chicago 50 and is a member of the Contra Costa County Task Force. He now works at Salesforce and continues to serve veterans as president of the Veterans Force in San Francisco. Over here, we have, the name tag says Edward Longmire, but he will be represented by Yuli Padmore. Yuli is an advocate, a longtime advocate for justice for the Port Chicago 50. She co-founded the East Bay Black Employee Collective and played a prominent role in the naming of the Thurgood Marshall Regional Park, home of the Port Chicago 50, and is a member of the task force. She also started and maintains a website dedicated to the history of the Port Chicago 50 and resources for exoneration efforts. Jody Irons, who will be portraying Ollie Green, is the executive director for the Contra Costa County Bar Association. She has over 20 years of experience leading nonprofit organizations as an executive director, including the Diablo Valley Foundation for the Aging, the Epilepsy Center, a foundation of Northern California, and Mothers Against Drug Driving for Northern California. She is an active member of the task force. Dorian Peters, who is going to be representing portraying Joseph Small, works at the California Department of Justice as Deputy Attorney General in the E-Crime Unit, where he prosecutes complex cyber crimes. He is appearing here today in his personal capacity. He is currently a director of the Contra Costa County Bar Association and was president of the organization in 2021. Jonathan Lee, who is seated on the side here, is an assistant United States attorney for the Northern District of California, where he has served since 2005. He is participating in this program in his personal capacity. He also serves as a director in the Contra Costa County Bar Association and as chair of the Port Chicago Task Force. I'd like to give a special shout out to Jonathan because he is going to be the leading narrator in the exoneration portion of this program. Jonathan was the instrumental in having this program, in basically getting me to put this program together. He told me about the exoneration efforts he was involved in several months ago, and I watched this reenactment when it was presented at the Inn of the Court in Contra Costa a couple months ago, and felt that it was a program that needed to be seen by the Federal Bar Association, the Ninth Circuit Historical Society, and our Northern District Historical Society. Everyone should know about this event. It's a subject that is very near and dear to Jonathan, and I give him credit for bringing it to our attention. I'd like to point out that Judge Gilliam will only be appearing in the reenactment section, not in the second part of this program, where's the discussion of the exoneration efforts. And now we will turn to the program. As I left something, oh, I'm sorry. I have three special guests that I'd like to introduce. Seated next to Jonathan is William Mims, who is a stevedore who loaded munitions at Port Chicago in the 1960s and 1970s. It's a pleasure to have you here with us tonight. Thank you. And seated next to him is Chanel Scales. No? What? Oh, okay. Oh, Sabrina Panelli, who is the co-founder of the East Bay Regional Parks Black Employees Collective. Okay, so now we will begin the program. During the, when we conclude the reenactment portion, Judge Gilliam will move into the audience because we're going to begin the advocacy section at that point. Okay, thank
you. Good evening. Today, we bring you a program that we hope will inform and inspire you. The Port Chicago 50 were a group of African American sailors who were convicted of mutiny at the height of World War II. Their story is part of our local community's history that is not fully appreciated or widely known. To set the scene, let us recall that America in the early 1940s was a nation at war, fighting the Axis powers of Germany, Japan, and Italy in Europe, North Africa, and the Pacific Theater. At home, America continued to be a segregated nation. Many African American leaders decried what was in effect a second battle for freedom undertaken on our nation's home soil. Since the end of Reconstruction in 1877, the rise of de jure discrimination through Jim Crow codes and widespread de facto practices such as redlining created two Americas, with African Americans denied equal rights to housing, employment, education, use of public accommodations, travel, and nearly every aspect of life. The same held true for the branches of the military service. Men who enlisted to serve their country, the same country that denied them equal rights, would instead be relegated to mess service in the Navy. Even to mess service in the Navy, if even allowed on a ship that were far from combat. One such place was Port Chicago?
Shortly after the December 7th, 1941 attack on Pearl Harbor, Congress approved plans for the establishment of terminal facilities at Port Chicago, California. Here is an aerial view of Port Chicago showing the pier. Situated on over 5,000 acres, the facilities at Port Chicago included a 500-foot-long pier for loading ships, a smaller pier, 4 barracks for enlisted men, a commissary, and a boiler house. Later, the Navy modified Pier 1 and began to load 2 ships simultaneously on May 10, 1944. At Port Chicago, the Navy used African-American sailors as stevedores, loading the ships around the clock. The pace was hectic, the work was arduous, and the working conditions were abysmal. The Navy did not train the sailors in how to handle or load the munitions. A local stevedore union offered to train the men at Port Chicago, but the Navy did not accept this offer. The officers, all of whom were white, demanded speed, pitting crews against one another in competitions, with officers placing wagers on the outcome. These were the ingredients for the disaster that followed.
We will now turn to the disaster itself. On July 17, 1944, at 10:18 p.m., a cargo vessel named the SSEA Bryan detonated in 2 successive explosions involving an estimated 3.5 million pounds of explosives, completely destroying the ship. Another cargo vessel, the Quinault Victory, which was empty, and 16 rail cars and the pier. Here is a diagram showing the 2 ships, the rail cars, and their arrangement on the pier. Here are some facts and statistics to help us understand the force of the explosion, along with some images of the destruction. The explosion's blast zone was approximately 15 miles, with broken windows reported in Benicia. The explosion involved the equivalent of 4,606 tons of TNT on E.A. Bryan, which was 40% full, and 16 rail cars with 429 tons. The explosion's force flung the other ship docked at Pier 1, the Quinault Victory, about 500 yards into Sassoon Bay. The explosion registered 3.4 on the Richter scale, and it was felt more than 450 miles away. The explosion created a crater 66 feet deep, 300 feet wide, and 700 feet long. A pilot flying an airplane at 10,000 feet of altitude reported seeing large pieces of debris from the explosion flying up near his aircraft. The Port Chicago disaster was the largest man-made detonation in recorded history to that point. The toll on human life was great. 320 sailors died. All of those who perished were on the ships, the pier, or immediate shore. Only 51 of the dead were ever identified. 202 of the fatalities were African American sailors, ranging in ages from 17 to 23. This was 15% of all African Americans killed in all of World War II. The wounded numbered 390, of which 252 were military and 138 were civilians.
In the immediate aftermath, the Navy ordered 328 African American sailors to clean up the disaster site. The cleanup was a gruesome task, requiring the survivors to retrieve fragments of human remains strewn around the blast site. None received survivor's leave, while white sailors did receive 30 days survivor's leave. By early August, Congress created a survivors' compensation scheme. Because of objections from Mississippi Congressman John Rankin, survivors received $3,000, which was 3/5 of the death benefits originally proposed. The Navy was never able to determine the cause of the explosion, but the Navy convened a court of inquiry, which blamed the black sailors, concluding, and this comes from the report, quote, "The colored enlisted personnel are neither temperamentally nor intellectually capable of handling high explosives." We will now discuss the events leading up to the Navy court-martial charging the Port Chicago 50 with mutiny. On July 30th, the Navy ordered the African-American survivors to Mare Island Navy Yard. On August 9th, the Navy ordered the men to return to the work of loading munitions. The men were afraid of returning to this dangerous work under the same conditions that produced the disastrous explosion that killed the men they knew and in many cases regarded as friends. The Navy marched the men in formation to the general area where the loading would take place, and when the order came to make the turn that would take them there unmistakably, many of the men balked and stopped marching. At first, 258 out of 328 sailors refused to go back to loading. The Navy put them on a prison barge, where they were confined in crowded conditions for 3 days, only leaving for the mess hall and taken there under armed guard. Whether the men held a meeting on the barge was one of the ensuing Mutiny Trials' focal points. On August 11th, Admiral Wright addressed the 258 men on the prison barge at Mare Island. He told them, "I want to remind you men that mutinous conduct in times of war carries the death sentence, and the hazards of facing a firing squad are far greater than the hazards of handling ammunition." After this, 208 of the initial group of 250 then agreed to return to work loading munitions. Several of them later testified at the mutiny trial, having been called as prosecution witnesses. Even so, the 208 sailors were convicted in summary courts-martial and sentenced to administrative discharges, with forfeiture of 3 months' pay and other service benefits. The Navy took statements from the men, including those who returned to load ammunition. At the mutiny trial, a point of dispute was whether the statements were involuntary because the men were coerced or under duress. Several of the men later stated they believed they were speaking to their attorney. Others reported that they signed statements after being threatened with long prison sentences.
The mutiny trial. The Navy convened a court-martial for the remaining men, known as the Port Chicago 50, who went on trial for mutiny at Yerba Buena Island. The trial lasted 6 weeks, from mid-September to late October 1944, with 32 days of proceedings generating more than 1,400 pages of transcript. The trial began on September the 14th, 1944, in a small courtroom on Treasure Island. The prosecution was led by Lieutenant Commander James Coakley, who served in the Alameda County DA's office. Before the war, he was Earl Warren's chief deputy prosecutor. After the war, he would be elected Alameda County DA and serve in that role until the 1970s. He prosecuted anti-war activists and Black Panthers in the 1960s, for example. The lead defense counsel was Gerald Veltman, who was an attorney practicing in Texas before the war. The prosecution theory of the mutiny charge was that a joint, persistent refusal to work by 2 or more men after a lawful order was sufficient proof of a conspiracy to subvert or override military authority. I think I'm going to read that statement again because it's very powerful. The prosecution theory of the mutiny charge was that a joint, persistent refusal to work by 2 or more men after a lawful order was sufficient proof of a conspiracy to subvert or override military authority. The defense countered that mutiny was defined by recognized military authorities, including Winthrop's military law, as the unlawful opposition or resistance to military authority with a deliberate purpose to usurp, subvert, or override the same. In a key pretrial ruling, the 7-member court-martial sided with the prosecution, denying the defense motion to dismiss the mutiny charges. The prosecution presented evidence to establish that in order to return to work was given to one or more of the men who refused. The prosecution called officers who testified that they gave the orders, both on August the 9th, when the men were mustered on Mare Island and marched toward a loading dock, and again on August 11th, when the admiral addressed the men and informed them that they could be shot by firing squad for refusing to return to work. The prosecution also relied on evidence of an August the 10th meeting of at least some of the men on the barge where they had been confined at Mare Island, including testimony of several African-American sailors who were on the barge. What came to light was that these witnesses gave statements that were not knowing or voluntary. These witnesses were also subject to summary court-martial proceedings, which were not completed as of the time of the trial, and later dismissed from service without retaining earned service benefits or credits.
5 lawyers each defended 10 defendants, raising questions about the effectiveness of the defense provided. The court precluded evidence of the working conditions they faced before the explosion, which prevented the defendants from putting on evidence of their awareness and their fear of danger in the working conditions loading ammunition. By contrast, the court allowed the prosecution's theory of conspiracy, in which evidence of some agreement by at least some of the defendants was received as probative of the culpability of all 50 defendants. These rulings constricted the concept of relevance when it would have allowed probative evidence of a defense, but broadened relevance to permit the prosecution wide latitude to claim it had proved its case against the entire group. There's a strong critique that the record evidence in the mutiny trial was insufficient to establish either the elements of conspiracy or the admissibility of statements by alleged co-conspirators offered by the prosecution. Finally, the court denied motions to exclude pretrial statements given by witnesses based on arguments that the statements were involuntary or coerced. This permitted the prosecution to use statements by other sailors who thought they were speaking to their own lawyer, or alternatively, who were told that if they didn't give the statement, they would face a long prison sentence themselves. This is another deep flaw in the proceedings, with the prosecution allowed to use statements of witnesses and defendants obtained through coercion and duress. Now, to bring the trial proceedings to life for you, we will use excerpts of testimony from the first 3 witnesses called for the defense. These 3 witnesses are representative of the defense of the Port Chicago 50, which rested largely on testimony by each member of the Port Chicago 50 testifying in their own defense. In one category, the defendants included some who did not receive an order to return to work loading ammunition, yet they were found guilty of mutiny. The first defense witness we will hear from is Edward Longmire. Would you raise your hand, please? Edward Longmire was an 18-year-old former poultry sales clerk from Cincinnati. He was the smallest member of the group and therefore the first to be questioned by the officers on August 9th. He was also the first witness called by the defense at the mutiny trial. We were unable to locate any image of Mr. Longmire. This is an excerpt of Longmire's direct testimony in which he described his willingness to load ammunition.
When did you return to Port Chicago from Shoemaker after the explosion?
I don't know the exact date, sir. I think it was in August.
Now, calling your attention to the 9th of August, how long had you been at Port Chicago prior to that date?
About a week or more.
A week or more?
Yes, sir, to my knowledge.
What type of work were you doing over at Port Chicago during that week?
Working on dunnage piles.
Did you load any ammunition?
No, sir.
Were you afraid to load ammunition?
Yes, sir, I am.
On the way from Port Chicago to Vallejo Naval Barracks, what, if anything, was said on the bus?
They talked about they were afraid of ammunition and the possibility of another accident and what they would do.
Did they say what they would do?
Yes, sir, they said they would run.
When you got out of the bus, what happened?
Lieutenant Tobin was walking toward us from that way, coming toward us, and told us to line up in alphabetical order. He called us out by names and initials in alphabetical order, and he talked about fear. He said, "Don't be afraid about ammunition." And he told us the kind of ammunition he was going to load, and then he said, "All men who were willing to obey all lawful orders that I give then fall out, and all who ain't stand fast." The men straggled up, mixed up, some stepped back, and after a while, we all crowded around Lieutenant Tobin.
Just a minute. You stated that you were the first man that Lieutenant Tobin talked to out of the entire division?
Yes, sir.
What did Lieutenant Tobin say to you?
He didn't tell me anything. He asked me questions.
What did he ask you?
He asked if I was willing to obey all lawful orders, and I say, "Yes, sir." And he looked at me and he asked me if I was willing to obey any orders that he gave, and I said, "Yes, sir, but I'm afraid of ammunition." He said, fall in and give Lieutenant Clement your name."
Longmire also addressed the meeting on the barge.
Now, on the barge, did you attend a meeting?
No, sir, I didn't attend a meeting. No meeting, sir.
Was a meeting held on the barge?
No, not that I know of. Any meeting was held on the barge, except the one Small told the boys to watch their conduct.
Wasn't it a meeting?
Yes, sir, I guess so.
Were you at the group of men where Small made a talk?
Yes, sir. I was downstairs when he made the talk.
Tell the court what you heard Small say.
I heard Small tell them to watch their conduct and cooperate with them, shore patrol and officers, and don't get in any more trouble.
What else did he say?
I didn't hear Small say anything else, sir.
Longmire's direct testimony then described the Admiral's talk on August 11th.
What did the Admiral say?
He talked about our race of people and the deal they was getting and the men he saw killed. And then I understood him to say something about shooting somebody. He said if any men kept refusing and not loading ammunition, he would call it mutiny or something and have them shot. And it took more nerve to walk in front of a firing squad than it took to load ammunition. He said, I don't remember everything he said word for word.
Thank you.
On cross-examination, Longmire did not waver in his testimony about his fear of loading ammunition, as opposed to whether he disobeyed an order to do so.
Did you hear anyone saying that they were going to load ammunition?
No, sir, I didn't.
Did you hear anyone say that they didn't want to load ammunition?
Yes, sir.
After you left Schumacher and went to the Port Chicago during that week or so while you were at Port Chicago, did you hear any talk among the men about loading ammunition?
Yes, sir.
All right. What talk did you hear?
They were afraid of loaning it.
Is that all?
No, sir, that's not all.
What else did you hear?
They talked about the possibility of another accident.
Longmire, did you receive an order to work on the 9th of August?
No, sir, I did not.
Did you receive an order to work on the 11th of August after the Admiral was there?
No, sir, I did not.
Did you give your name to Lieutenant Clement on the 9th of August because you hadn't received an order to work or because you were afraid of ammunition?
I gave it to him because I was afraid of ammunition and because Lieutenant Tobin told me to give my name to Lieutenant Clement.
A second category of witness testimony by the defendants included at least one sailor who was on sick leave at the time of the alleged mutiny, recovering from injuries that would have prevented him from loading ammunition. This sailor, also convicted of mutiny, was Ollie Green. We'll now hear an excerpt of the direct examination of the defense's second witness. Ollie Green was a truck driver from the Washington, D.C. area. At 37 years of age, He was one of the older members of the Port Chicago 50. In his direct testimony, Ollie Green described his work status after the explosion and his willingness to return to loading ammunition.
Mr. Green, were you injured as a result of the explosion?
Yes, sir.
In what way?
A couple of scars on my leg, lower and upper, and around the eye and through the chest from flying glass.
You were in the Mare Island Hospital for about 10 days, is that right?
Yes, sir.
On the morning of August 9th, I call your attention to that date. Were you mustered as a division?
No, sir. I wasn't mustered that morning. That morning, when the division was called out for muster, I was upstairs in the barracks laying in my bed.
Why were you in the barracks?
I had broken my wrist the day before.
After a sick call report was introduced into evidence as Exhibit 4, the defense elicited the following testimony.
That sick call report was given to you on the 8th of August
The 8th of August.
because of your broken wrist?
Broken wrist, fractured wrist.
On the morning of August the 9th, Ollie Green was outside in front of the barracks. He testified he heard Lieutenant DeLuca say something about the men disappointing him, but no orders. The direct testimony continued as follows.
Are you afraid to load ammunition?
Yes, sir.
Were you afraid to load ammunition on the 9th of August?
Well, afraid to load ammunition before that, too, after the explosion.
On the morning of August the 11th, Ollie Green described being marched from the barge where the men were being held to a ball diamond. The admiral spoke to the men, but Green could not hear him. Lieutenant DeLuca said to the men, "All who are willing to obey any kind of order, step off over to the west side, and the ones who didn't want to, step over to the east side." Green testified that most of the men went to the west side initially, but then some started moving back to the east side.
Did Lieutenant DeLuca say, "I order you to load ammunition"?
No, sir. Lieutenant DeLucci never gave me any order.
Did anybody tell you, "I order you to go load ammunition"?
No, sir.
Getting back to your hand, what did the doctor tell you when he gave you that slip?
He said this hand wouldn't be well for about 6 weeks on account of my age.
How old are you?
37.
The following is an excerpt of the cross-examination of Ollie Green.
Did you say no because you were afraid to load ammunition, or because you didn't receive an order? Which was it?
I said no because I was afraid of ammunition.
You did say no then, didn't you?
Yes, sir, I did.
And before you broke your wrist on the 8th of August, did you intend to say no if you were ordered to load ammunition?
If I was ordered to load ammunition, I would have had to load it.
Then you were ordered to load ammunition.
I had never been ordered to load ammunition.
What did you mean a while ago when you said the reason you said no was because you were afraid to load ammunition?
Well, he asked me, was I willing to go back to work, and I told him no.
You were not willing to go back to work?
I said I couldn't go back to work at that time because I had a broken wrist.
Then your state of mind was such that you were so afraid of ammunition that you would disobey an order if you got one?
No, sir. I wasn't going to disobey any order.
You weren't so afraid that you would disobey an order?
No, sir. I wasn't going to disobey any order, but I am afraid of ammunition.
At the end of his testimony, the court asked if he had anything further to state, and Green replied.
I got a couple of things to say, sir. The reason I was afraid to go down and load ammunition, them officers, the guys down there loading ammunition, racing each division to see who put on the most tonnage, and I'd knowed the way they was handling ammunition, it was liable to go off again. If we didn't work fast at that time, they wanted to put us in the brig. And when the exec came down to the docks, they wanted us to slow up. That is exactly the way. Put it on fast. If we didn't put it on fast, they want to put us in the brig. That is why my reason for not going down there.
Finally, we will hear from one of the defendants who received an order to return to loading ammunition, but refused to comply with the order because of the hazardous conditions at Port Chicago. This witness was Joseph Small. Joseph Small, Sr. was a 23-year-old truck driver and mechanic from New Jersey. He was a de facto leader of the enlisted men at Port Chicago. For example, he regularly called cadence for the men at the request of the white officers. During the trial, prosecutors identified Small as a ringleader of the alleged mutiny.
Mr. Small, what happened on the morning of August 9th?
Well, the first muster that they started, Woods, the petty officer, and myself started to call the muster, but we were interrupted by Boyer, so that muster was never called. Then Boyer ordered the men to face right, forward march, column left, and I was walking with him. I bumped into Woods as he stopped.
Were you in ranks?
No, sir.
Where were you?
Marching on the left side behind the petty officer.
Calling your attention to back now to the column left order, what happened?
Well, I noticed the men had stopped, and Lieutenant DeLucci was speaking to one of the men in the division.
What did Mr. DeLucci say?
I can't state his exact words, but he said, if you're not going to work, fall out.
What happened then?
Well, nothing happened the next few moments. They all stood up and looked. And then the next thing I noticed, Boyer was writing names on a piece of paper.
What did DeLucci say to you?
He asked me, was my name on the list? And I told him, no, sir.
Did he ask you why?
Yes, sir. He asked me why. I told him that if the list pertained to men loading ammunition, I didn't intend for my name to be on it.
Why not?
I was afraid of the ammunition. I told him I would obey any order except for the order to load ammunition.
You testified you were at Port Chicago, is that right?
Yes, sir.
After the explosion at Port Chicago, what took place?
Well, after the explosion, I was thrown out of my bed and got a few cuts around. All the men were running wild here and there, and I started for the back door. But the porch fell before I got there, so I stopped. Then I got myself together and turned to help the other men out, the men that were injured.
When did you go to Shoemaker?
Well, during the morning, we were transferred to Port Chicago to Camp Stoneman, and the following day, the early part of the afternoon, we were transferred from there by bus to Schumacher.
Did any of the men tell you that they were afraid to handle ammunition
Yes, sir.
at Shoemaker?
Yes, sir.
Now, going back to the morning of August 9th, did Chaplain Flowers talk to the 4th Division on that morning?
Yes, sir.
Prior to Chaplain Flowers' talk, had Lieutenant DeLucci given an order to go load ammunition?
No, sir.
Prior to Chaplain Flowers' talk, had anyone given you an order to go load ammunition?
No, sir.
After Chaplain Flowers' talk, what took place?
The men were mustered back in ranks again, lined up, and were marched in the front of the barracks C, down to in front of the reviewing stand.
What happened then?
Well, we marched down there and given the command, left face, and faced the reviewing stand, and Lieutenant DeLucci spoke.
What did he say?
He said he was terribly surprised at the actions of the 4th Division, that we had given him a hell of a letdown, that he didn't expect that of us. He thought we were men enough to hold up when the going got hot.
Did he at that time then say, I order you to go load ammunition at the Naval Ammunition Depot?
No, sir.
Now, while you were at the Vallejo Barracks, did you see a list or lists of men, names of men?
No, sir.
Did you sign any list indicating your refusal to go load ammunition?
No, sir.
Did you ever attend a meeting at Vallejo?
Not until we were on the barge.
What date was that?
It was the date before the Admiral spoke. I think it was the 10th,
What date were you taken onto the barge, Small?
the afternoon of the 9th.
Mr. Small then testified about a meeting of the men on the lower deck of the barge, at which he was the only one to speak.
What took place, sir, on the lower deck?
Well, all the men were, well, not all of them, the majority of them were gathered down there when I got there.
What did you say?
I said, all right, fellas, knock it off. Listen to what is to be said. It is as much for your good as it is for mine. Then I went on to tell them they had to knock off the horseplay around, obey the shore patrol, take orders that were given to them by the officers, or else it might result in them calling in the Marines. I told them it would be much worse under Marine Guard than it was at the present time. that they could make it much better for themselves if they would just cooperate in that respect. I told them if they pulled together, they will find out things would be much easier for them.
What did you mean by that, Mr. Small?
I meant to pull together and keeping them some straight, one to the other. If one got off wrong, it was up to his shipmate, his pal, whoever it might be, to tell him, straighten up and fly right, knock it off, get back in line.
In other words, you meant to keep order. Isn't that what you meant?
Yes, sir.
Did you make the statement attributed to you by other witnesses that we have the officers by the ass,
No, sir.
or we have the officers by the tail,
No, sir.
or we have the officers by the balls?
No, sir.
What happened the next day?
I noticed 3 or 4 lieutenants coming down the docks. So I said to the boys, something's up. I don't know what it is, just like that. And then Lieutenant DeLucci hollered from the dock to have all the men fall out into divisions.
Who did he call?
Me.
Go ahead.
We all fell out into the divisions and lined up. And we were marched from there, one division following the other, out into the ball field.
Did you hear any statement by anyone of the 4th Division to the effect that we will not go to work for the white motherfuckers?
No, sir.
You heard nothing of that nature?
No, sir.
After the Admiral spoke, what happened?
Lieutenant DeLucci said, I have been ordered by my superior officers to order you men to go to work. All men that are willing to obey all orders anywhere at any time fall in behind me.
What happened then?
Well, for 15 or 20 seconds, they all stood still. And then 2 fell out in the front ranks, just about in the center. 2 men fell out, and the whole division followed them, all except 4 or 5.
Why did you move over with the 4 or 5 men?
Because I misunderstood his remarks wrong. At first, he said, all men that are willing to obey orders at any place, at any time, fall in over here. At that time, I realized that the order could be to load ammunition, and that was one order that I wasn't willing to obey.
Why not?
I was afraid of the ammunition.
Why were you afraid?
I had worked in the ammunition 10 months, and from the way it was handled, I could expect the same thing anytime. I expected it.
You mean that there was danger in handling ammunition?
That's right. Yes, sir.
And the danger in handling ammunition was something that made you afraid to handle the ammunition, is that correct?
Yes, sir, it is.
Was your fear brought about by the explosion?
Yes, sir. The majority of it, yes, sir.
Now then, after the 11th of August, after the Admiral's talk, when you were taken back down to Shoemaker, where were you quartered?
Oh, after the 11th of August, I was sent to the station brig in Schumacher.
Were all of the men taken to Schumacher after the Admiral's talk? Were they all quartered in the brig?
Yes, sir.
How long did you stay in the brig?
Well, I don't really know. Shortly after then, I was put in solitary confinement.
We'll now hear excerpts of Mr. Small's cross-examination.
How old are you, Small?
23, sir.
Where'd you live before you came into the Navy?
New Brunswick, New Jersey.
What was your occupation?
Truck driver.
You refused to march to the ship on the 9th of August, didn't you?
Well, I stopped after I bumped into one of the petty officers that was walking ahead of me.
I'll ask you a question again. You refused to march to the ship on the 9th of August, didn't you?
We were never told we were going to the ship. We got the command column left, and everyone stopped. I bumped into the petty officer, and I stopped too.
When you heard column left, did you know what you were going to do?
I didn't know, but we had an idea
What was your idea?
that we was going to the ship.
To load ammunition?
Yes, sir.
Because when you got the column left, that would take you down the river from where the ferry was to take you across the ship, is that right?
Yes, sir.
And you had made up in your mind before that you were not going to handle ammunition, hadn't you?
Yes, sir.
You had made up your mind that you would obey any orders except the order to handle ammunition?
Yes, sir.
At that time, when the 4th Division received the command column left, you refused to go, didn't you?
I had to stop. I bumped into the petty officer. I couldn't walk over the top of him.
Will you answer that question yes or no? Either you refused or you didn't.
I didn't go.
In a conversation with 2 officers on the 24th of August at Shoemaker, you also said, I refused 3 times to load ammunition, and I am still refusing?
Yes, sir.
And that's true, isn't it?
Yes, sir.
Now, what 3 times were you ordered to load ammunition, and what 3 times did you refuse?
I have never been ordered to load ammunition.
When was the first time that you refused to?
Lieutenant DeLucci asked me if I was going to load to Port Chicago and work with him. I told him, no, sir. The second time was he asked us all if we were willing to load ammunition. I told him, no, sir. Then another time, the chaplain asked me, would I consider loading ammunition? And I told him, no.
In addition to that, you refused again out on the ball field after the admirals talked to you, didn't you?
Nothing was said to us about loan ammunition that day at all, not from Lieutenant DeLucci.
What was said?
He told us his superior officers had ordered him to order us to go down and load ammunition, but he never did order us to go.
On October 24th, 1944, following deliberations lasting 80 minutes, including the lunch hour, the court-martial found the Port Chicago 50 guilty of mutiny. The Port Chicago 50 received sentences of 8 to 15 years of hard labor. NAACP legal counsel Thurgood Marshall traveled to the Bay Area to observe the trial. Marshall held a press conference and announced that the defendants were deprived of basic due process. Marshall told the press that all American society was on trial. Marshall held a second press conference to announce that the NAACP was requesting a government investigation into the working conditions at Port Chicago. After the trial, Marshall represented the Port Chicago 50 for purposes of their appeals. Both post-trial to the court-martial convened at Yerba Buena Island and later to the Secretary of the Navy. We will repeat selected arguments Marshall made concerning the mutiny trial, taken from his typewritten briefing preserved in the NAACP Legal Defense Fund's files, along with numerous other case files involving the mistreatment of African American service members in the 1940s. In the Port Chicago brief, Marshall argued as follows regarding the treatment of the men as a unitary whole rather than 50 individuals.
Mass prosecutions of this type, calculated to dispose of a large group of men with one swoop, militate against our whole traditional concept of personal guilt, in the hope that by proper administration of our procedure, an innocent man shall never be convicted through a callous indifference as to the fairness and integrity of the trial to which he is subjected.
Commenting on the conspiracy evidence, Marshall argued that
the entire case against the accused is built upon testimony as to statements allegedly made by other accused and by parties not accused, and even worse, by unnamed, unidentified individuals with no connection whatsoever to either the accused or the alleged crime.
pointing out the speed of the deliberations, Marshall wrote,
Although the record of the actual trial of the case includes 1,435 pages, single-spaced and on legal-sized paper, the court arrived at its findings of guilty between 11:55 a.m. and 1:15 p.m. Even if we assume that the entire 80 minutes was spent in deliberation on this case, each individual accused received about a minute and a half of deliberation. This callous disregard of even perfunctory justice is amazing.
Marshall argued that the court erred when it refused to use the definition of mutiny in a treatise of military law.
Mutiny has been variously described. It may, it is believed, properly be defined as consisting of unlawful opposition or resistance to or defiance of superior military authority with a deliberate purpose to usurp, subvert, or override the same, or to eject with authority from office.
Marshall argued that there was a lack of evidence to support a finding of mutiny.
In order for a mutiny to occur, there must be a defiance of or resistance to superior military authority with a deliberate purpose to usurp, subvert, or override the same. The record shows only the refusal of the men to obey the order to load ammunition because they were afraid. There is no evidence of any attempt to usurp superior authority. There is no evidence of an attempt to override superior authority. The men were respectful in their attitude toward their superiors. They were afraid to handle ammunition and told the officers they were afraid as a result of the explosion.
Marshall's appeals were unsuccessful.
In May 1945, the war in Europe ended. With the use of the 2 atomic bombs at Hiroshima and Nagasaki in August 1945, the war in the Pacific came to its end on September 2nd, 1945. In January 1946, all of the Port Chicago 50 were released from prison. After this grant of clemency, 47 of the men returned to service in the Navy. All of those men were granted a general discharge. The Navy officially eliminated all racial barriers in February 1946. On July 26, 1948, President Truman issued Executive Order 9981, desegregating the entire U.S. military.
These events, from Port Chicago to Executive Order 9981, proved to be a catalyst for the emergence of the civil rights movement as a leading force for social change in America. Within the next decade, the Supreme Court decided Brown v. Board of Education, siding with Thurgood Marshall's arguments. Rosa Parks and the Montgomery bus boycott and other direct, nonviolent actions focused increased attention on civil rights, and the murders of 14-year-old Emmett Till, civil rights leader Medgar Evers, and other violence sparked outrage. During this post-war period, the NAACP published a pamphlet titled, Remember Port Chicago. In 1989, Dr. Robert Allen published Port Chicago Mutiny, based in part on his interviews of members of the Port Chicago 50, after he found the NAACP's pamphlet so many years later. One of the interviews was Joseph R. Small Sr., who, as we have heard, was a leader among the enlisted men. Years later, when the Navy reviewed the Port Chicago incident in the 1990s, concluding there was racism in the Navy, but that it did not play a role in the events of Port Chicago. Mr. Small explained that most of the Port Chicago 50 did not want a pardon because that implied they had done something wrong. Instead, they wanted the mutiny convictions set aside and compensation for all lost pay.
We've only scratched the surface of the history of the Port Chicago 50 tonight, but at this point we want you to hear about those experiences from some of the Port Chicago 50 in their own words. We'll now hear 3 brief excerpts from recorded oral histories from Port Chicago. Credit for these reportings, made more than 25 years ago, goes to Long Haul Productions. In the first excerpt, 3 members of the Port Chicago 50, Joseph Small, Albert Williams, Freddie Meeks, and another man, Percy Robinson, who survived the explosion but returned to work, described the events leading up to the mutiny charge.
He came down and explained to us what our responsibilities were.
He told us, he said, well, one thing I want to tell you, that you could be charged with mutiny if you don't go back to work.
And he explained at that time, if we refused to go back to work, he could have us shot.
That was the cue. When he said you could be shot, Then the fellas went to mumbling. You know, a lot of people, they afraid to die.
From my upbringing, my mother taught me that if a white man threatened to hang you, he would do it at his first legal chance. And she told me about the Klan, and she was brought up in Mississippi. So I believed that they had a legal chance to shoot us. So I was afraid. So I said, well, I'm not going to give them a chance to shoot me. I'll go back to work.
But then 50 of us decided we wasn't going to go back to work. If we was going to get shot, we just had to shoot us because we wasn't going to go back and load no more ammunition.
That's when we were arrested. I would say arrested because we was all shipped to, I think it was Treasure Island. We was at the stockade. Then we was found out that we was charged with mutiny.
We didn't commit no mutiny. We didn't take over no ship. We didn't take over a base. We had no weapons. We didn't even have a pen. We only refused to go back to work. Now, how could that be mutiny?
I didn't know anything about mutiny. I just knew that I didn't want to work under the same conditions that I did work under and advance the chance of the same thing happening again.
Well, the mutiny trial, it's just like a thing that is cut and dry. We all sitting over here, all the white officers over here. We wasn't allowed to say anything but whatever they would ask us.
They would call us one by one up there and testify, and everybody had almost the same story. Maybe that's why you thought we was, but that's a story we told them. I told them the same thing I told them then that I told them when I was on the docks, that I was afraid of it.
In the second excerpt, approximately 45 seconds long, Joe Small, Freddie Meeks, and Albert Williams, in that order, describe their reaction to the guilty verdict.
Was guilty. The verdict was guilty as charged. I expected it from the way the trial went. Of course, the length of the sentence was a surprise.
The lowest sentence in there, I think, was 8 years. I had 12 years, and some had 16.
Well, I don't know. I don't know whether I don't even remember crying behind it. I know I did after I got into prison for a while. But I just seemed like it was something that was going to happen then after the trial. You know, after you sit in the trial for a few days and you see what was going down.
In the final excerpt, Albert Williams, Joe Small, Freddie Meeks, and then Albert Williams again explain the impact of the mutiny trial on their post-service lives.
Well, in the war ended, after they had suspended our sentence, they had to release us. We get our discharge.
My discharge from the Navy prevented me from receiving jobs that I would have received as a civilian. It branded me as a person incapable of following orders.
I used to couldn't talk about it because it would hurt. It would hurt inside. You didn't want your friends to know that you was in the service and you had been charged with mutiny. You didn't want people to think that you didn't like your country or something, that you do something like that. That's the only country we knew about.
Not even with the fellows I work with. I didn't talk with my wife or children. Every time I would bring it up or even think about it, it looked like I got a hateful feeling in me, and it was just about to tear me apart. I just hated the other race. And that hate was building up. It stayed with me. The hate stayed with me. Hate can really destroy a person. I could have been a better father, I believe, if I hadn't had that hate. I wouldn't abuse it or nothing, but I just, things that I didn't talk about, things I held in, things I think I could have did better.
With those words in our minds, we will now turn to the final part of our presentation, in which Julie Padmore and Jonathan Lee will discuss recent local efforts to seek exoneration for the Port Chicago 50.
In February 2022, the Contra Costa County Bar Association formed the Port Chicago Task Force with two goals in mind. One, to raise awareness of the injustice that happened at Port Chicago in the legal and the broader community, and two, to advocate for the setting aside of the mutiny convictions of the Port Chicago 50. I should say that there are about 15 members of the task force. There are lawyers and non-lawyers, lawyers who are local, some lawyers in other parts of the country, and non-lawyers from other parts of the country, including at least one descendant of a gentleman who was killed in the explosion at Port Chicago. That was his uncle. And we're honored by all of the members of the task force and their diligent efforts. The task force believes that exoneration of the Port Chicago 50 will address several aspects of historical inequity. The first area is racial discrimination and systems that construct and reinforce inequality. The Navy and other branches of the service were formally segregated, as you've heard. Whites could be officers. African Americans worked in menial or undesirable assignments only. The men who created the conditions for the Port Chicago disaster, the admirals and other officers in charge of the Navy, were not held to account for it. The Port Chicago 50 were, as we have noted, convicted of mutiny. In addition, the other sailors who originally refused, but later returned to loading ships, received summary court-martials, had conduct discharges, and forfeiture of 3 months' pay. Although the sentences imposed on the Port Chicago 50 were commuted after the end of the war, the convictions remained, casting a pall over their service and our nation's history. Although nearly 80 years have passed since the Port Chicago disaster, that is, unfortunately, a brief passage in the struggle for civil rights. Generations of Americans have called on the nation to do better, and the nation has too often been slow to act. Many did not live to see change. For example, Dr. Martin Luther King, Medgar Evers, and Emmett Till, to name just a few. But they and their fellow Americans entrusted these issues to the succeeding generations to get it right. The task force is advocating for exoneration in the belief that it is never too late to make good on that ideal, and that now is that time.
The second area is the absence of due process of law. The mutiny trial was fundamentally flawed. 5 lawyers represented 50 sailors. Evidentiary rulings permitted testimony of allegedly conspiratorial statements without attribution, while excluding evidence of the conditions facing the sailors as they lived and worked at Port Chicago. These are representative examples of how the trial proceedings were tilted in favor of the prosecution, depriving the accused sailors of due process of law. There are strong national interests in preserving, advancing, or restoring the rule of law to one grounded in impartial and even-handed justice. Exoneration will reassert the importance of due process of law by emphasizing that we as a nation are willing to correct historical injustices where our justice system fell short of our national values. In its advocacy work, the task force has asserted that a presidential pardon, an expression of forgiveness granted after, and I'm going to say that again, I apologize. In its advocacy work, the task force has asserted that a presidential pardon, an expression of forgiveness granted after an applicant demonstrates acceptance of responsibility and good conduct is inadequate in the case of the Port Chicago 50 because the men did nothing wrong. Instead, it is incumbent on the nation
to accept the responsibility, my apologies,
for their unjust conviction and make it right through exoneration.
there is precedent for this.
Thank you. I thank you, Mr. Mims. In 1945, then Captain Charles McVeigh was the commanding officer of the USS Indianapolis, which was torpedoed by a Japanese submarine and sank with tragic loss of life. Only 315 sailors survived out of a crew of over 1,100. A general court-martial convicted Captain McVeigh of negligently failing to steer the ship on a zigzag course. In 2001, Congress exonerated Captain McVeigh by including a provision in annual defense spending legislation directing the Secretary of the Navy to place a statement in Captain McVeigh's military record that recognized his lack of culpability and exonerated him for the loss of the USS Indianapolis and its crew. The task force has joined others who have sought exoneration by calling on Congress to follow this precedent by exonerating the Port Chicago 50 through legislation. Others who have similarly requested congressional action include the Friends of Port Chicago, the East Bay Regional Park District, and the California State Assembly.
The third area involves the issue of protests against lawful authority as distinguished from an armed uprising. Our nation has a long history of protecting lawful protest. We are currently examining the contours of those issues with the hundreds of prosecutions arising from the January 6th Capitol riot. The current proceedings against the January 6th defendants are noteworthy for their individualized assessments of each participant, from charging decisions that track culpability of conduct, bail decisions that consider individualized risk of danger or flight, and sentencing outcomes that weigh each individual's conduct as well as any mitigation. By contrast, the Port Chicago 50 Mutiny Trial treated the sailors as a unitary whole. As we have heard through the selected testimony, some of the men did not receive an order to return to work loading ammunition, and at least one was in a sick call status, unfit to work, but the proceedings made no such distinctions. Moreover, there was no allegation that any of the Port Chicago 50 ever took up arms or was even impolite to the command, and yet they were convicted of mutiny. The Port Chicago 50 refused to return to work under unsafe conditions that led to the deaths of 320 sailors, but they expressed readiness to work if the conditions could be made safe. This conduct highlighted dangerous conditions imposed on the sailors and would be considered protected whistleblowing by today's standards. Exoneration will recognize that the Port Chicago 50 deserved due process, acted reasonably, and called attention to unsafe conditions created by their commanding officers. There are strong national interests in each of these outcomes.
The fourth area involves inequity in judicial proceedings due to overcharging allegedly criminal conduct. We are also engaging in a national conversation about whether certain forms of conduct should continue to be viewed as
criminal offense, or whether prosecuting authorities are overcharging certain forms of conduct generally or members of different groups in society. This too is an aspect of the Port Chicago 50 chapter. There are those who argue that the charge, if any, should have been disobedience of an order, not mutiny. There are others who argue that there should have been no charge against the Port Chicago 50 because what they disobeyed was an order that lacked moral authority. Instead, the Port Chicago 50 received the stiff penalty of a mutiny conviction, staining their time of service, their lives after war, and their legacies to their family members. The task force believes that exoneration will bring healing to those directly affected by the mutiny convictions of their fathers, uncles, grandfathers, and so on. And it would begin to repair the damage done to the impartial rule of law. The restorative benefits of exoneration to the Port Chicago 50 and their descendants, as well as millions of Americans who want to see our nation live up to its stated values and creeds, are an important outcome of our nation.
The fifth argument concerns lawful dissent against an unlawful or immoral order. The Port Chicago 50 refused to return to work loading ammunition in the unsafe conditions that preceded the explosion. The orders given to them to load the ammunition violated safety standards and the government's regulations for the handling of ammunition generally. Ordering the sailors to work in these conditions was thus unlawful. Additionally, the orders placed the sailors in a position of risk that no sailor should experience then or now. The orders imposed the heightened risk only on the sailors, who had earlier cited the dangerous conditions to their commanding officers. The commanding officers, nevertheless, pressed the sailors to return to work in those same conditions. The task forces argued that we as a nation want to encourage members of the military to question or resist unlawful orders or orders that lack moral authority. The photos of soldiers torturing prisoners at Abu Ghraib prison, or the accounts of the massacre of villagers at My Lai during Vietnam, are but two examples of historical precedents in which we would want as a society for our service members to be able to dissent. This same reasoning applies to the Port Chicago 50. They refused to return to work loading munitions in the dangerous conditions imposed upon them by their command shortly after cleaning up the remains of their fellow sailors killed in the Port Chicago explosion, while their white counterparts were given approved survivor's leave to cope with the disaster at home with family and friends. The decision of the Port Chicago 50 to refuse to return to work loading ships was rational, reasonable, and should be viewed as lawful dissent. By contrast, we prosecuted Nazi generals and soldiers at Nuremberg because they carried out wartime orders that represented crimes against humanity, rejecting arguments that they were simply carrying out orders from a superior officer. We must recognize the cruel irony of our treatment of the Port Chicago 50 as we prosecuted them for mutiny, a crime that was punishable by death because they disobeyed an order that lacked moral authority. The exoneration of the Port Chicago 50 would serve the important societal purpose favoring the lawfulness of military orders and the peaceful dissent against orders lacking legal or moral authority.
Finally, there is much in our public discourse about the essential role of the rule of law in our society. But the rule of law settles our expectations as a society only when it is just. Our notion of what is just evolves with our national experience. A century ago, we were a nation living under a regime of race relations validated by the Supreme Court's Plessy v. Ferguson decision. Brown v. Board of Education established a new rule of law just a decade after the mutiny convictions of the Port Chicago 50. The Port Chicago Task Force believes that the correction of an unjust outcome of any legal system is a test of its strength and the strength of the rule of law. Because when our legal system reaches back to correct the mistakes of the past, it is tested by its ability to engage in self-examination and self-reflection. And as a result, the rule of law is strengthened. The Port Chicago disaster and subsequent mutiny trial are such a test.
In closing, we hope that you will make the story of the Port Chicago 50 a story that you tell in your professional networks and social circles. What happened at Port Chicago is too important to allow the story to fade. In fact, as you have heard tonight, efforts to correct the injustice of the conviction of the Port Chicago 50 through exoneration are ongoing and gaining momentum. As Dr. Martin Luther King so eloquently put it, injustice anywhere is a threat to justice everywhere. We are caught in an inescapable network of mutuality, tied in a single garment of destiny. Whatever affects one directly affects all indirectly. Dr. King's statement was part of a broader argument set out in his famous letter from Birmingham jail about justice and about the unjustness of laws that discriminated against African Americans. He argued that one definition of an unjust law was any law that a majority created to restrict the rights of the minority without the participation of the minority in the law's creation. This is in essence what happened in the Port Chicago 50 mutiny trial, as we have heard tonight. The proceedings were unjust, and the outcome should be wiped clean. With Dr. King's guiding principles in mind, we hope that you will consider joining the efforts to secure exoneration for the Port Chicago 50.
Those efforts range from congressional action, such as recently introduced resolution in the House of Representatives, offered by Representatives Mark DeSaulnier, Barbara Lee, and John Garamendi to exonerate the Port Chicago 50, and more grassroots efforts such as an ongoing petition at change.org/Port Chicago, or search for Exonerate the Port Chicago 50 if you are interested in joining over 1,100 others in signing.
And finally, on the council table here tonight, we have some exoneration brochures prepared by the East Bay Regional Park District, by Yuli and others there. There are color brochures. Feel free to take one of those with you tonight if you would like. There's a copy of Dr. Allen's book there so you can see what it looks like. That's my personal copy, so please don't take it. And there's an excerpt of the Ollie Green testimony if you'd like to see what the transcript actually looks like. Thank you all very much.